that if you did not do what I asked you, then your bond would be raised and you would have to go back to jail, right?
No.
Yes, that's exactly what I say, because I say, you've heard me say it probably 8 times already this morning. So at this time, Mr. Brown, because you did not do what I asked you to do, or what I ordered you to do, I'm going to raise your bond.
Challenge subject matter jurisdiction.
That's overruled. Listen, Mr. Brown, I'm raising your bond to $100,000 in each of your cases for not following the court order. Go back with the bailiff. Go back with the bailiff. Go back with the bailiff. You're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. Go back with the bailiff.
She started.
Don't make me lay hands on you.
Why would you lay hands on me?
Because you're not doing what I'm telling you. Now go.
Mr. Brown, you need to go back with the bailiff. There's right now, I've raised your bonds. You have to go with the
I am not
bailiff.
a threat to any officer.
You through in, Judge?
Yes, I'm through.
I am not a threat to any officer.
Let's go.
Why are hands on me?
Yeah.
Why are
I
hands
told
being
you.
put
I
on?
told you I was going to put hands on you.
Why are hands being put on? Do y'all see this on the camera?
Good morning. You're Armand Gregory. And Mr. Gregory, were you able to get someone hired?
No, ma'am. Yes.
Who'd you talk to?
We had 3 calls that got prices for one.
Speak up, please.
I got prices for one, and Mr. Walker, I talked to Mr. Walker. Clayton, Fresh Out, and Mr. Gaines,
Who?
McLean.
Okay. And so where are you on being able to get someone hired?
All their price was too high. Mr. Walker just told me it was too expensive. So
Are you working?
um,
Why not?
I was working out of town, so I couldn't go out of town, then come back.
Gotcha. So thank you for talking to those lawyers, Mr. Gregory. I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely. You're going to swear under oath that it's all true, and then I'll take a look at it, okay? Step in front of the clerk on the end. She'll give you that paperwork. Tyrania Johnson. Good morning.
Thank you.
Is it Tyrania?
Tyrell.
I say it wrong every time. I'm sorry. Ms. Johnson, were you able to get a lawyer hired?
No, ma'am. I have a reason. Well, I did talk to 3 of them. I talked to Mr. Brobos,
Yeah.
Mr. Joseph, and Mr. Wright. But in the process of me talking to them, I had court, and they told me it was going to combine it with this court. And she told me that I was going to get an attorney appointed to me.
What other court do you have?
I had it. It was my misdemeanor, and they told me they didn't want to interfere with this because it's dealing with it. So she told me they was going to combine it. But when I messaged her,
Who is that? Who told you
it's
that?
British.
Okay. So typically what that means is usually they'll handle your felony first. But you still, it doesn't get combined in one court. So I don't want you to misunderstand. So if you have a court date down there, you still have to go. So sometimes they'll do things with your cases that are kind of similar, but it's definitely 2 different things, 2 different courts. Okay.
Yes.
So, are you working? Are you able to hire someone?
Yes, ma'am, like that.
You think you'll be able to hire someone?
Yes, ma'am.
Okay. So if I give you one more reset, can you get that taken care of?
Yes, ma'am.
All right. So make sure when you go, let them know that you do have both of the cases, one in felony court and one in misdemeanor court.
Okay.
But this one is definitely the one, obviously, that's more serious, to make sure you try to get someone hired.
Okay.
If for some reason you can't, talk to at least 3 others, bring me those names, and then we'll discuss your options. Okay. All right. Step in front of the clerk. Cedric Martin Harris. Good morning.
Good morning.
You're Cedric Martin Harris?
Yes, ma'am.
And Mr. Harris, this is your initial appearance. In cause number 26, DCCR 0421. You're charged with the state jail felony offense of burglary of a building, and that's from February 4th of 2026. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? So what I'm going to do, Mr. Martin Harris, is reset your case for about 30 days to give you some time just to see if you can hire someone. If you do get someone hired, bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Yes.
If you're not able to hire a lawyer, I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand? Step in front of the clerk right here. She'll give you a reset. Jurikia Holland. Good morning. How do you say your first name? Jurikia, and you're Jurikia Holland?
Yes, ma'am.
And Ms. Holland, this is your initial appearance in cause number 26, DCCR 0386. You're charged with a second-degree felony of aggravated assault with a deadly weapon, and that's from February 5th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No.
So what I'm going to do, Ms. Holland, is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer, and they'll tell you what to do.
Yes, ma'am.
If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers you talk to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand?
Yes,
All
ma'am.
right, step in front of the clerk. She'll give you your reset notice.
Mr. Yeah.
Keyshawn Spriggs. Good morning. You're Keyshawn Spriggs.
Yes,
You
ma'am.
look very nice this morning, Mr. Spriggs.
Thank
Mr. Spriggs, this is your initial appearance and cause number 26, DCCR 0665. You're charged with indecency with a child, and that's from March 4th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes, ma'am. I have a consultation at on the 17th with Mr. Marcus Wilkerson.
Okay,
Yes.
so what I'll do, Mr. Spriggs, is reset your case for about 30 days to give you some time to see if you can get him or someone else hired. If you do get Mr. Wilkerson hired, make sure you bring the reset notice that you get today to him, and he'll tell you what to do.
Yes, ma'am.
If you're unable to hire him or someone else, make sure you visit with at least 3 others. You'll see that they all charge different amounts, different payment plans. Bring me the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options.
Yes, ma'am.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand?
Yes, ma'am.
All right, step right here in front of the clerk. She'll give you a reset. All right.
Would he just make that?
Joshua Tyree. Good morning. You're Joshua Tyree. And Mr. Tyree, this is your initial appearance. You have 3 cases. Cause number 26, DCCR 0078. You're charged with unlawful possession of a firearm by a felon, and that is from September 21st of 2025. And then in cause number 26, DCCR 0079, you're charged with the 3rd-degree felony of tampering or fabricating physical evidence with intent to impair, also from that same date. And then in cause number 26, DCCR 0080. Just a second. You're charged with the 2nd-degree felony offense of possession of a controlled substance, also from September 21st of 2025. Since you've made bond in your cases, have you had an opportunity to try to hire a lawyer?
No.
So your indictments also allege 3 prior felony offenses, which mean all of these you will be considered a habitual offender which means if you're found guilty, your punishment range is a minimum of 25 years up to 99 years or life in prison. You understand?
Yes, ma'am.
So it's very important that you try to get someone hired before that next court date. I want to reset your case for about 30 days to give you some time to try to hire someone. If you get somebody hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what you need to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you will go back to jail. Do you understand?
Yes.
Also, was it a requirement that you were told that you were to wear a drug patch?
Yes.
And you have that on? All right. So it's very important that that drug patch is obviously negative. I get those results. So every 2 weeks, you have to go get it changed. Make sure you get it changed on time and that it's negative. If there's a positive result, your bond's going to get raised and there'll be a warrant. You'll go back to jail. Okay.
Yes, ma'am.
All right. Step in front of the clerk. Darian Broussard. I've got a, good morning, you're Darian Broussard. Give me just a second, Mr. Broussard. Let me read this real quick. So when you were here last time, I had you go get a drug patch. Well, I know you did, but then you didn't go get it changed when you were supposed to.
I had fired.
What?
When I went to jail, I got fired from my job. Sorry, man.
Have a seat in the jury box. Let's get you tested this morning. Nasir Brown. Are you Nasir Brown? Either AB or Hinton here this evening. They're usually my backup.
And just for record, I want y'all to know that's not mine, that's Charlie's.
Just wait a minute till we get somebody back in here.
And this one.
Huh? Yeah. Hey, I just looked up. I said, "Where's my backup?"
Yeah.
You're the first, yeah.
That station. Right.
This one. Amon Colbert.
Yeah. Yours is gonna be something.
You're Amon Colbert.
Yes, ma'am.
Mr. Colbert, don't wear sweatpants to court.
Oh, I'm sorry. I'm sorry.
It's felony court. You need to dress appropriately. All right. So were you able to get someone hired?
I was told I was supposed to go with Mr. Rennick, but Mr. Rennick went up on me, so I talked to Mr. Bailey, and he has a girl named Haley out there. Haley, pay her, and she told me she wasn't gonna be able to take the payment because the court date was so close.
Right.
So she told me to make a payment this week to start up a payment plan
Okay.
and reset if I get one,
Sure.
and then she'll take it from there.
And it's Haley.
I don't know her last name. I'll have to call Mr. Bailey.
Simmons?
I think
Does
so.
that sound right?
The Jensen Bailey, something like that.
Okay.
It's all right.
If you'll just make a notation, Kim, on there that he's going to hire, I think it's Haley Simmons, just maybe a question mark with Jensen Bailey's name beside it also. You need to get someone hired before that next court date. Okay? Step in front of the clerk. Hi. No, I'm glad you did because I couldn't, and I knew it. I just couldn't, and for the longest time I had it on a sticky note because I had a, yeah, I don't know another one. Wesley Mack. Yes.
Hey, bad.
Happy Monday. Good morning.
Good morning.
You're Wesley Mack. And Mr. Mack, this is your initial appearance in cause number 26 DCCR 0776. You're charged with the third-degree felony offense of tampering or fabricating with physical evidence, and that's from March 15th of 2026. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? So what I'm going to do, Mr. Mack, is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts of different payment plans. Bring me those names of the lawyers you've talked to when you come back, so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you could go back to jail. Do you understand?
Yes.
You'll step in front of the clerk right here. She'll give you that reset notice. Sierra Mitchell. Good morning, ma'am. He's good. Okay. You're Sierra Mitchell. And Ms. Mitchell, this is your initial appearance in cause number 26 DCCR 0779. You're charged with the state jail felony offense of abandoning or endangering a child with intent to return. That's from March 31st of 2026. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Okay.
All right. So what I'm going to do, Ms. Mitchell, is reset your case for about 30 days, give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do.
Okay.
If you're unable to hire someone before the next court date, I'm ordering you to visit with at least 3 lawyers. They all charge different amounts of different payment plans. Bring me back the names of those that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand?
Yes, ma'am.
You'll step in front of the clerk right here. She'll give you your reset notice.
Oh, chucklehead today. What you did?
It's Nasir Brown.
You gave me something else, but
No, it's yeah. He's one of the, he's trying to be a sovereign
Sovereign
citizen, I
citizen.
think.
I wrote it up.
He's not.
You did that last time.
Yeah. I remember.
I didn't do it. You shouldn't good.
Rory Parker. Good morning, sir. You're Rory Parker.
Yes, ma'am. Good morning.
And Mr. Parker, next time, please do not wear sweatpants to court, okay?
Yes.
Mr. Parker, this is your initial appearance in cause number 26 DCCR 0782. You're charged with driving while intoxicated, third or more, and that's from February 25th of 2026. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? All right, so what I'm going to do, Mr. Parker, is reset your case for about 30 days to give you some time to try to hire someone. Thing. Are you, do you have that ignition interlock device on your vehicle?
Yeah.
Okay. So I'm going to, if you get a lawyer hired, I'm going to give you about 30 days. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Okay.
If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. You need to bring me back the names of the lawyers that you've talked to so I know that you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order. You would go back to jail. Do you understand?
Yes.
If I test you this morning, Mr. Parker, you can have anything in your system?
No.
Let's double check that. Have a seat in the jury box, please. Lamudra Walker? I know I said that wrong. I'm sorry. Good morning, ma'am. How do you say your first name?
Lamondra.
Lamadra. And you're Lamadra Walker?
Yes.
And Ms. Walker, this is your initial appearance in cause number 24 DCCR 0846. You're charged with forgery of a governmental instruments, a state jail felony from February 14th of 2023. Since you've made bond, have you had an opportunity to try to hire a lawyer?
I got a court-appointed lawyer.
You did. So what happens is everybody that gets arrested on a felony gets an automatic court-appointed attorney.
Okay.
But once you bond out, I expect you to at least try to hire your own lawyers. So I'm going to reset your case about 30 days to give you some time to do that. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, different payment plans. Bring me the names of the lawyers you talk to so I know you're trying, and then we'll discuss your options. If you don't do that, then you run the risk of me raising your bond for not following that court order, and you would go back to jail. You understand?
Yes.
All right, step in front of the clerk. She'll give you a reset notice. Del Mario Whitfield. It's today.
I had found it when it died.
Good morning, sir.
Morning.
Did I say yours right?
Yes, you actually did.
Okay, Del Mario Whitfield. And Mr. Whitfield, you look nice today also. Figure I fuss at people for not looking nice, so I'm gonna let those know that do. Mr. Whitfield, this is your initial appearance in cause number 26 DCCR 0672. You're charged with the state jail felony offense of driving while intoxicated with a child under 15. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? So you've heard Mr. Whitfield, I'm going to reset your case about 30 days, give you some time to get someone hired. If you do get someone hired before that next court date, just bring the reset notice to that lawyer. They'll tell you what to do. If you're unable to, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts of different payment plans. Bring me back those names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond and you would go back to jail. Do you understand? All right, if you step in front of the clerk, she'll give you a reset notice. So this last one needs a thumbprint still. You see that on your, I'm sorry. That's okay. I just see the note on there. Wesley Smith. Wesley Smith. Well, may not matter.
We'll get over that.
That was a big bucket to have only one no show. Huh? Well, no, that was pretty good for initials, though. That's what I meant. Yeah.
No response, Shona?
Will be forfeited for non-appearance and reset at 100,000. Mr. Broussard, you can come back up, sir. All right, Mr. Broussard, you tested negative, which is great. It's very important that you do the best you can to get that changed every 2 weeks, okay?
Yeah, for that, keep.
Okay.
No money.
Good. Okay, sounds good. Do the best you can. And then you're on probation down in misdemeanor court, so you can expect to be tested through them as well. So we'll keep up with it that way. So, Mr. Were you able to get a lawyer?
I talked to several.
To 7?
And they literally, I got it all down in that hotel.
Okay. Thank you for doing that. And
4,000, 3,000, 500.
Okay.
So very much because it's like $1,000 down.
so do you think you'll be able to get him hired if I do one more reset?
Yes, ma'am.
Okay, I'm going to reset your case one more time. See if you can get Mr. Burbank hired. If so, just bring the reset to him. If not, see if you can talk to some others. And if you still can't, we'll discuss your options at that next court date. Okay? Just step in front of the clerk. She'll give you a reset notice. And if you'll just write Burbank on this for me.
Yes.
Let's see, Mr. Comerford, are you ready on Ryan Ramey?
Yes, Your Honor.
Good morning. Morning.
You file something, I haven't changed. It's just a special measures.
Good morning, sir. You're Ryan Ramey.
Yes.
And this is cause number 25 DCCR 1246. Mr. Remy is charged with driving while intoxicated with a child passenger. It looks like just recently there was a motion to suppress filed. Is that something, do you believe, Mr. Comerford, that would be dispositive of the outcome of the case if I hear it prior to trial?
Yes, Your Honor.
Okay, so let's do this. I'll set it for a hearing on that in the next 30 days or so. We'll find a time when we have a couple hours at the most. I wouldn't think it would take more than an hour or two.
Okay. I haven't looked at it, Judge, but
Okay. And then I'll go ahead and take care of that. That way you guys know how to proceed, depending on the outcome of that.
I have a jury trial July 8th, so I just want to make that availability. We can just anytime in July and be fine, just not last week.
Okay.
That-
No, it won't be on a regular date. I'll have to find a date for us to have some time for the hearing. Just make a notation for me and we'll take a look at it. If you'll put not July week. Okay.
Thank
All
you.
right. Stay in touch with Mr. Comerford. He'll let you know when you need to be back and ready for that hearing. Okay. All right.
Thank you,
Thank you. Mr. Paget, you have Michael Harrison Jr.
Yes, Your Honor. Yes,
Good morning, sir. Are you Michael Harrison Jr.?
Yes, ma'am.
This is 25 DCCR 1859. Mr. Harrison is charged with driving while intoxicated, third or more. And what is the announcement?
Your Honor, we reviewed the evidence, received an offer, and if you would give us a plea date, needs to arrange some time on weekends for.
All right.
Sure.
Any issues? No, you've got the ignition interlock device. Make sure you keep that, take care of that. And we'll just do a normal reset for a plea on the
Yes,
plea
Your Honor.
docket. We'll take care of it on that day. All right.
Thank you, Your Honor.
Thank
Have
you.
your excuse.
Yes, sir.
Thank you.
See, Judge Walker, you've got Daniel Ward's sentencing. That one's done. That's for you. Okay. I need that. Thank you. Good morning.
How are you, ma'am?
Good. How are you?
Monday morning. Hey, something. How are you? Good.
Good morning, sir. Are you Daniel Ward?
Yes, ma'am.
And Mr. Ward was previously in court and cause number 25 DCCR 1375 entered a plea of guilty to driving while intoxicated, third or more. I've received that pre-sentence report. If you both had an opportunity to review that report.
Yes, ma'am.
Yes.
Yes, Your Honor.
Any additions or corrections?
The only thing I would add to it is they've determined to be a moderate to severe risk. The issue that I have with that is that the bulk of his criminal conduct is 21 years ago
Right.
and 24 years ago. The last DWI that he had was 13 years ago. And what I would ask Judge is simply, I don't take away from what his history shows, but being that it's been 13 years before he's had any issues with drinking whatsoever. If the court is inclined to move forward with the JCDI program and various programs, I would simply ask maybe the court consider ordering it, but holding it in abeyance. And if he has any issue, any hiccup whatsoever while he's on probation, then about that. But 13 years is a pretty good amount of time.
Well, I agree with you on that. The issue that I've got really is from that substance abuse assessment, which doesn't really have anything to do with the length of time or what the history is. It's just what's going on now and what their determination was. And their determination was severe alcohol use disorder as well as severe sedative disorder. And I think to make sure that he is successful, I am inclined to order what they have requested so that we don't have any issues.
If I may, to say, I think I've always said the best indicator of future behavior is when you've done 13 years is an incredibly long time to go for anybody. So at the end of the day,
Well, how long have you gone?
I've gone for 61 years, Judge.
Right.
But at the end of the day, but for the grace of God goes I. And
Same here.
so anyway, whatever the court's wisdom, the only other
Thank
thing
you. I appreciate that.
he does have to do 10 days as a condition.
Yes.
He's full-time employed.
Okay.
We have asked that he do it on weekends.
Yes, no problem with that.
No sooner.
So any issue with starting this weekend? It would be from Friday. You'll go in Friday at 6. They'll let you out on Sunday and you'll do that.
If you can do it, great. If not, she just needs to know a date.
Can I have like a 2-week notice, like not this weekend, but the following?
Are you working this weekend?
Yes, ma'am.
Okay, so here's what I'll do, Mr. Ward. I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of driving while intoxicated, third or more. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that. Place you on probation for 5 years. You're ordered to follow all of the rules and conditions of probation. That includes paying a $500 fine. You will be ordered to serve the 10 days upfront time, and I will do some dates on that in just a second. Also, I am going to order that you enter and successfully complete that JCDI program. I understand and respect what your attorney's asking for, but just based on the information that I have, I think it's important that you have those tools up front so that this doesn't ever happen again in 1 year or however many years. All right. So you will be ordered to complete that program. If you do everything that you're supposed to when you're on this probation, this is a great opportunity because you'll be able to serve that sentence while you're out on probation. The other side of that is if you violate any condition of probation, you can be brought back into court and you could be facing that 10-year sentence in prison that you've already agreed to. Do you understand? So we're going to start your weekends on June 19th. So that's a week from this Friday. And you'll go in Friday at 6 o'clock to the Jefferson County Jail. It's important that you're on time. If you're late, you can be considered a no-show. Obviously, if you don't show, it's a violation of your probation. It's very important that you don't. Some people think, and I know this isn't going to be you, that if they show up intoxicated, they're going to sleep it off for the weekend. Please don't do that. That's obviously a violation of your probation. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with your attorney, okay? You need to have a seat here in the courtroom. Probation is going to call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, sir. Thank you. Oh, okay. Okay, I hope you show that you'll go grab it real quick. You can come up, Mr. Parker. All right, Mr. Parker, you tested negative, which is great, obviously. You're going to get over here and get your reset notice. Make sure you try to get someone hired and follow all of those rules, okay?
Yes, ma'am.
Thank you. He's got that one. Mr. Rojas, you have Fernando Garcia.
Good morning. I'll have to translate for Mr. Garcia.
Thank you, Mr. Rojas. Oh, wait, I don't see paperwork yet.
Oh.
Just want to give the credit that I didn't bring them.
That's right. It's on there.
Thank you. And for the record, Mr. Rojas, you're going to translate for Mr. Garcia, correct?
No.
Good morning, sir. Are you Fernando Garcia?
Yes.
And Mr. Will your client waive the formal reading of the indictment?
Hey, William.
Mr. Garcia, in cause number 25, DCCR 1144, you're charged with the state has elected to proceed on the lesser included offense of evading arrest or detention, a class A misdemeanor. And that's from July 12th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal? So you can't change your mind later if I follow this agreement. You understand?
Yes.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
And it looks like the agreement that you've reached is for a 1-year deferred probation, $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Garcia is not competent?
No, yeah.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made and defer all proceedings and place you on probation for 1 year. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you don't have a conviction on your record. And at the end of the probation period, if you're successful, the case will actually be dismissed. You'll never have the conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the Jefferson County Jail for up to 1 year. Do you understand?
Yes.
I'm handing you the trial court certification. That shows that this was an agreement that I followed. And so you have waived your right to appeal. If you'll just have a seat here in the courtroom, probation will call you up when she's ready to go over your paperwork. And Mr. Rojas, if you'll help with that.
I will.
Thank you.
Thank you, Judge.
We didn't know what was happening. Where they are.
Mr. Macon,
Yes.
I don't see you on my docket.
I just realized I'm in the wrong part.
Good morning. Nice to see you.
I'm just nervous.
That's okay. Mr. Parker, you have Christopher Rhodes.
He's here, Judge. I just found I have.
Good morning, sir. You're Christopher Rhodes.
Yes, ma'am.
This is 26 DCCR 0209, and Mr. Rhodes is charged with driving while intoxicated with a child passenger. What is the announcement?
We have an agreement, but they need to re-indict him. And so I think Mafino said a couple weeks or.
Judge, he provided the mitigation documentation this morning to allow me to re-indict this to an endangering from a UWI child passenger
Okay.
so that he may receive deferred. I could have it indicted on Wednesday and be ready to plead sometime in the next 2 weeks.
All right, we'll just do about a 2-week reset. And Mr. Rhodes, make sure you stay in touch with Mr. Parker, and he'll let you know when that next court date is, and we'll take care of it. We'll put it on a plea docket on that next court date.
Yeah.
All right, free to go.
Thank you.
You get that'll be a plea docket, Anna. Thank you, ma'am. Regina Williams. Good morning.
Good morning.
So this is Miss Malfino.
Ashley.
Miss Malfino on Regina Williams. Good morning, ma'am. You're Regina Williams. And this is 26 DCCR 0218. And what is the announcement?
Your Honor, she's informed me has documentation that she's supposed to provide today. Which I think will resolve the case if it says what she says it says, but I have not seen it. She told me she can have it today, and I'm asking for like a 2-week reset.
So why haven't you gotten that to Mr. Parker already?
Because the people didn't meet me to sign the affidavits at the notary, but they said that they'll meet me today.
Okay, so I'm gonna do about 2-week reset.
Yes, ma'am.
Well, let's do this. I'll just do a normal reset, okay? Get that as quickly as you can to
Yes,
Mr.
ma'am.
Parker because he needs to get it to Ms. Malfino so she can take a look at it, and then it may or may not make a difference in your case, but she'll take a look at it once that's done. If for some reason that doesn't happen, then when we come back, we'll need to do something with the case, okay?
And Judge, if I may, just to reiterate what the court said, based on her prior criminal history, it's not likely that that affidavit's going to suffice.
Okay.
But I'm happy to take a look at it, but I will make 2 alternative offers.
Okay, thank you. So make sure you visit with Mr. Parker before that next court date as well. Okay, thank you.
They said I have another one, but I don't have the bond. I
I
don't.
don't have anything else.
Okay.
You stay in contact with your.
Mr. Galmore, you've got Austin Talbot, sentencing.
Yes, sure.
Sentencing. Austin Talbot. Good morning.
Morning, Josh. How are you?
Good. How about you?
All right, fantastic.
I do. I have. Right, sir, you're Austin Talbot. You want to switch with Miss Malfino, please? Thank you. And Mr. Talbot was previously in court, entered pleas of true in a motion to revoke his probation to counts 1 through 6, is on probation for aggravated assault. It was a 5-year deferred probation that he received in March of 21. And then a 5-year term for burglary of a building, as well as a misdemeanor driving while intoxicated. And I received the updated precedence report. Have you both had an opportunity to review that report?
We have, Your Honor.
I have, Judge.
Okay, so the burglary of the building and the DWI were both, they were actually first. He was on probation for that when he was placed on probation for this case. Those are
Expired.
expired. So we're currently just on the aggravated assault, which technically expired, but the motion kept it open. So we can do whatever we want on that one, correct?
Yes.
And you both had an opportunity to review that report.
We have, Your Honor.
Yes.
Any additions or corrections?
No corrections.
Ms. Malfino?
No, Judge, other than the fact that, I handled all of these cases before this court. The burglary of the building involved the Little League, down in Lake County, if you'll recall. Obviously, it was quite some time ago, but we were all here. And I do have notes reflecting the, level of fear of the original complainant. I have not had the opportunity to study in depth the original PSI, but I know the court has it as well. I just ask you take those things into consideration in addition to the fact that with those prior the DWI here and other history here, he has subsequently pled true to a new offense. I know that's more argument than addition, but that's all I have, Judge. And unless the probation department, and this gentleman is here for Ms. Broussard. I thought it was going to be Ms. Broussard, but I'm happy for him to add anything.
And what's your name for the record, sir?
Mr. Broussard, Dallin Broussard.
That's what I thought.
Yes.
Okay.
I was about to say, I thought that was, yes, nice to see you, sir. Do you have anything to add to the updated report?
Nothing to add. No, ma'am.
Okay. And what is the status of that?
It's pending. He has a court-appointed attorney in that county. It's up north. The only discussions they've had as of right now is that it looks like they're going to offer him probation, but nothing has occurred yet. He's got another court date.
July 21st.
July 21st.
Or 24th.
We believe the case will be resolved on that date. If the outcome of that date makes a difference to the court, we'd be more happy to reset this until just after that next court date. But we do believe that the outcome is going to be probation there.
Yeah, I mean, it's still a misdemeanor, but it's the second. So it's a class A, I guess.
That's correct.
All right, go ahead, Mr.
I would say, Your Honor, since we were here last, the plan was for Mr. Talbot to be able to continue to go to work where he's working. He moved into kind of this process and the court allowed him to transfer and work there. But since we were here last, his child or his son's been in the hospital pretty much the whole time. We do have a letter here. He came from the hospital yesterday. His son's in the Texas Children's Hospital. He has not been able to work since he's been here. He has not made a single payment since we were in court last. He has not really been able to work either since we were here last. So unfortunately, he's just dealing with his son's medical condition, and that's all I've been able to do as far as financials is concerned. Of course, the only thing he pled true to was basically the financials and this new offense, which occurred out of the county. So there's a few technicals along with that.
So what's your?
Well, Judge, what we're asking the court to do is consider either continuing his probation. I believe he's already reached the expiration date, but for this, he would have successfully concluded his probation. But because of this, we would ask the court to extend his probation, which has there's a lot of time left that the court could extend, or just reset and see what the outcome of the DWI is going to be. But I do believe it's probably going to be 2 years probation with interlock requirement.
Ms. Malfino?
Judge, I will defer to the discretion of the court because he has not had any other violent type of issues and because he has that issue with his child, which of course I know everyone's sympathetic to, whatever you think is.
What was the date of the offense of this DWI second? When did that happen?
I don't remember. It's like a year, almost like that.
May of 25. All right, so here's what I'm going to do, Mr. Talbot. I'm going to find that you entered your pleas of true to counts 1 through 6, freely and voluntarily. Well, let me ask this. Do you have an interlock device on your vehicle now?
I'm not driving. I have a handheld.
You do?
Yes, ma'am.
Okay. And you've agreed not to drive?
Yes, ma'am.
All right. So what I'm going to do is find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation. I'm not going to do that. I'm going to extend your probation by 2 years. I am going to order that as a condition of your probation, you enter and successfully complete the JCDI program. I understand that without driving and with having issues with your son, that could be difficult, but it's going to be required regardless of what else is going on.
Is that his probation was transferred to Angelina County? Is that something that Angelina County will do?
If they have, most counties have some type of program that is similar. And so whatever similar program they have, I would be willing to order that I'll have the probation officer look into that, but it has to be more than just, testing and stuff like that. I want an actual program. And if they don't have one, then get back with me. We're gonna have to figure something else out. This is the last opportunity you're going to be given here. You've been given a whole lot of opportunities. It will not matter what else is going on in your life. If you are unsuccessful after today, you will be looking at prison, and it's between 2 years and up to 20 years. So you've got to think of not just short term with what's going on with you and your family, but long term to be able to be around as well. Do you understand?
Yes, Your Honor.
All right. So there was no agreement on this. And so you do have some rights to appeal. I can't imagine why you would want to, but I'm going to hand you that. Mr. Gallimore, if you guys will sign off on this real quick and give him that bottom copy, and then just talk to probation. Today, Mr. Broussard will let you know what you need to do so that he can look into whatever program they have up there in that county. What is that, Diboll County, or is Diboll Angelina County? Okay. We'll check into that. Thank you, sir. Thank you for being here. Good luck to you.
Thank you, Joe.
Thank you. Ma'am. And you can, if you'll go stop and talk to probation right over there.
We start seeing all the probation officers, kids, be probation officers, we've been here a while.
Yeah, we have.
It's true.
Let's see. Mr. Gertz, you've got Remington Boykin.
Judge, can we hold on that?
Yes. And then Edgar Castillo. Edgar Castillo.
He's present, Judge.
Very different.
What? Okay.
Good morning, sir. You're Edgar Castillo.
Yeah, ma'am.
And this is 25 DCCR 1052. Mr. Castillo is charged with evading arrest or detention with the use of a vehicle. And what is the announcement?
We have a deal worked out. We're gonna need to have a little time to sign everything up.
I'll hold it. You're going to do that today? Yeah.
I believe so.
Okay. Just have a seat, sir. Blaine Dunnigan. Hold that.
Please, Judge.
And then Toy Frazier.
Boy. Yes, we can reset that with permission from the.
Good morning, sir. You're Toy Frazier.
Yes, ma'am.
And this is 25 DCCR 1494. Mr. Frazier is charged with giving a false name or information or forging a vehicle registration. And what is the announcement?
Judge, we're asking for a little time on that. If we could have a normal recess so Ms. Bonfino and I can discuss.
Judge, this case actually was the tax assessor director.
Yeah, I'm just looking. It looks like you were signed on in October of last year. So this will be the final reset. So make sure y'all get together, visit Mr. Frazier. Make sure you stay in touch with Mr. Gertz. Once he gets any information, we'll get an announcement at the next court date. Okay, thank you. You're free to go. Make that notation, please. Felicia Freddie.
All right, Judge, I'm gonna do this ring. We've got getting ready for this other trial this afternoon.
Good morning. You're Felicia Freddie. And Miss Freddie, this is an MTRP and cause number 24 DCCR 1390. What is the announcement?
Judge, if we could have a few minutes, I think I'll be able to get this resolved today.
Okay, sure. I'll hold it.
It's an MTRP, Judge. So.
Thank you. Just have a seat, ma'am. Okay. And then you've got Miguel Martinez, Mr. Gertz.
Yes, Judge. He's present.
Right, so you're Miguel Martinez. This is 25 DCCR 0584. Mr. Martinez charged with aggravated sexual assault of a child. And what is the announcement?
Judge, the state made us an offer and we have made a counter offer in the case. And I think the state needs to get input from the family, is my understanding. And so they're not saying no, they're just saying, let us check. So I don't know if you want to do 2 weeks or 3 weeks.
I'm going to do 2 weeks. It'll be the final reset. It looks like this has been about a year.
There is a possibility that I'll be in trial in Lufkin in federal court on that day, but we will let you
Just
know.
let us know and we can push it a week or two if we have to. Make sure you stay in touch with Mr. Gertz so that once he visits with Ms. French, you guys know, because this will be the last reset point announcement.
Yes, Your Honor. Stovall's popping.
Yeah, and Dan Church.
Oh, yeah. And
It's a bond hearing, right? Dan Church. That's with Miss Malfino. Good morning, sir. You're Dan Church.
Oh, yes, ma'am.
And this is 26 DCCR 0612. Mr. Church is charged with deadly conduct, discharging a firearm. And the state has filed a motion asking that well, I'm looking at the state's motion. The motion it says aggravated assault, but the charge is deadly conduct. That just
I'm sorry, Judge. That's my error. I was
Okay.
trying to file it rather quickly after receiving the affidavit from the complainant. I'll fill the court in on that as to why I don't have a witness present.
looks like the current bond is set at $20,000. The state has asked to raise that bond. Ms. Malfino?
Excuse me, Judge, and I apologize about that error. Obviously,
That's fine.
the court would see the probable cause affidavit. It's very similar to an aggravated assault, discharging the weapon somewhat in the direction of the complainant. In this case, I have had multiple conversations with Jeremy Shelton, the complainant. He is the across the street neighbor of Mr. Church. He is a very nice young man. He was very forthright, came in and presented me or had an affidavit authored by himself with one of my investigators in lieu of coming to docket today. He, as the court can probably surmise, is of the mind that he doesn't want to aggravate the situation. Nope, not intending to use that same word, but I will tender that as State's Exhibit number 1, just for purposes of this hearing. And I have Mr. Gertz, it's his affidavit just expressing concern about the nature of this offense and the fact that they reside across the street from one another, that he has a very young son and a wife who were also present at the time of this offense. And he has concern that Mr. Church may be keeping weapons at his sister's house down the street. I have worked very closely with my investigator, Mr. Bays, and he is familiar with Mr. Church as well as Port Arthur Police Department is. And we've asked that some things be implemented in the interim time period to hopefully assure the safety of all the parties, including Mr. Church. I just wanted to bring this matter to the court's attention with that motion.
And by this point, a clear theme has emerged across this entire courtroom session. Opportunity comes with conditions. Some defendants are being given resets to find lawyers. Others are receiving deferred probation, treatment requirements, or another chance to comply. But the judge repeatedly makes the same point. These opportunities only work if the defendant follows the rules. One missed appointment, one positive test, one new violation, or one ignored court order can completely change the outcome. So the real question isn't whether the court will give someone another chance. It's whether that person will actually use it.